You're welcome back. This is Newsfile. It's your most authoritative news analysis show. And in the next 20 minutes, we'll try and answer the question that I have been asking. Why is it such big news that a lawyer gets a 3-year ban? And don't forget, I'm asking that with the benefit of visiting the General Legal Counsel's website and seeing a number of lawyers, at least in this year alone, who have suffered various punishments, including those who have, if you check throughout last year and all, those who have lost the right to practice as lawyers. They've lost it completely and forever, unless an appeal process changes it. But Francis Osu's one appears to be rare. And I joined the group that said this was unreasonably harsh. Why are we saying that? Let's hear Samuel Kujeto, who is a senior advocate of the Supreme Court of Ghana and a former president of the Bar Association, Accra, right, who has issues with what our reaction is to what they have done as a disciplinary committee.
It is not a mean thing. And many of you also do not understand, and the many lawyers do not understand when we tell them that they should read what is happening in other jurisdictions. The professionals are put in a unique position whereby you can manipulate innocent people. And that if we are not harsh and tough in disciplining them, then what we are doing is a floodgate. Everybody can do what you like. First of all, but he agreed to pay this money to me. We agreed, this is a contract we signed. We said the contract you signed is irrelevant. The contract is that, was I in accord with the code of ethics? Was it in accord with the scale of fees that the bar has laid down? This is the whole issue. So unfortunately, I cannot discuss that matter with you.
It means that you have a lot of disciplinary issues that you're dealing with.
Lots of them. Loads of them.
Amazing.
And now you must go to the website, because now we want them, as soon as you come, you are on the website.
Oh.
So you cannot do it in secret.
Very interesting. All of these things, hearings used to be quiet and nobody heard about them. He's saying that now this is how it goes. And you've seen that certain news media houses appear to have realized that there's news on the Ghana General Legal Counsel's website. So they visit there regularly and they get to publish what is going on there. I'll start with Ace, and is the reason I won't let Ace go without us taking advantage of him to discuss this matter. That's why we are bringing this issue and dropping the rest that we have. Two other issues, the Chinese nationals and the issues about donating to the Attorney General, which people are appalled at it, and also the 50 million scandal, fraud, payroll at the Youth Employment Agency. We can discuss those matters later. Ace, you are one of those who is suggesting that this is harsh. Why?
Well, I haven't heard of a 3-year suspension before. Maybe it's happened before, but that is what shook me. I mean, punishments being meted out to lawyers, I've seen and read many of them. But a 3-year suspension suggests that this was, or the disciplinary committee and the General Legal Counsel considered this particularly egregious, that it was so bad that it is a 3-year suspension. And even when his license is restored after 3 years, he has to practice under a senior, for the senior to vouch that. Now, that I've seen that in other jurisdictions, but seriously, I hadn't seen it here before. My knowledge is limited. It was on a number of issues. The other thing was that, you see, what we read, I believe, was a press release. And it was the release alone. It didn't seem to give us more of the information that we are now hearing after the release. One of my first suggestions would be that going forward, well, I believe that there are records of proceedings which will show exactly what went into it. But I think we should be receiving the rulings, the reasoned rulings, stating the facts and then the decisions, so that we can appraise it better. Because just seeing the 1-page letter didn't seem to provide sufficient ground. So a lot of information has come in after the fact, which suggests that there's more here than meets the eye. Let's deal with the issue of advertisement. And you're right, your opening statement was right, that the law bans it. The LI says that there will be you can't apply or seek instructions for professional business. You can't do anything that reasonably can be regarded as touting, advertising, or calculated to attract business unfairly. And advertising is publicity, promotion, marketing, publicizing, publishing, trumpeting. When we talk about touting, we are looking at selling, hawking, peddling, vending. I mean, basically, you are not allowed to sell your services. And this is rooted in the history of the profession. In fact, our profession is so, especially the barrister side of it, is so, pardon me, money averse, which is strange, it's ironical, that the gown we wear has a little pouch at the back. Apparently, in those days, when you finish arguing, your clients put the guineas in the pouch.
Okay.
Because you can't handle money. I wonder what happened when we go to chambers. You know, but you can't handle the money. But the interesting thing about the gown today is that even when we wear them, that pouch is sealed. Thank you, that's been put in our hands. But when all of this provision exists, the law then permits, you see, people have made the argument, if there's no advertisement, there can't be any advertisement. So some advertisement is permitted. If it's a necessary consequence of the proper exercise of your profession. So let's say a lawyer has been involved in a case, the case is over, and he got 2-minute interview. As long as he's not delving into the depth of it and saying, look, this is good for Ghana, it's a judgment that, etc., etc. If it's deemed to be a proper exercise of his profession or any act otherwise properly done by him, then that level of advertising is permitted. Indeed, in spite of the rules, or maybe in appreciation of the rules, the General Legal Council on 15 July 2013 approved law firms having websites.
5th July.
5th July. Reading and
right.
Everything. 5th July. Yes, 5th July 2013. Approved websites with rules on how you advertise on the internet. And so we are all guided by this. For example, it can include your full name, location address, contact, telephone contact, email address, passport pictures of the partners, associates, and juniors, the history of the firm, profile of areas of practice of the firm, and even your clients, if they have approved it. Earlier, the Bar and the General Legal Council had approved listings. So if you go through it, there's Martindale Habel, where you actually pay to be listed. There's International Financial Law Review, which reviews lawyers. But you see, what has happened is that technology, and of course, and sorry, let me say that there are limitations. There are things you can't do on the website,
right,
or on any internet publication. You cannot indeed put out statements about your success. That is where some of the issues arise.
You're not supposed to use phrases and adjectives and descriptions such as best and expert. So you're not supposed to criticize another law firm.
There are rules on how you advertise. So the claims around that there's a complete bar to advertisement is not real. As recently as 2013, we started getting real. But you see, you can't say it yourself. But there are worldwide rankings of lawyers. Let's be honest with ourselves. You don't say it yourself. If you look at chambers, look, international business will go into a country and look at chambers. Who are the ranked lawyers in chambers? So chambers sits in London and ranks lawyers. Band 1, Band 2, Band 3. That's the fact. So you may not call yourself an expert, but chambers will call you an expert. And that's why I kind of bristle when people refer to you as a legal luminary. I'm like, look, I've not illuminated anything. Don't call me a luminary, you know. And suddenly we start calling people human rights expert, commercial law expert. I always give the example. The Association of Registered Professional Bodies, through the bar, invited me to give a presentation during the bird flu matter. Okay. So I spent some 30 minutes reading the local legislation on poultry and did a presentation. The next day I was in the newspaper as a health law expert. I haven't read health law ever in my life. The press like to drop these names to give their story some gravitas, to give it some credibility. Please, we are not experts, so stop calling me an expert. I'm just a lawyer. So the question here then is that I think that we need more, because then out of this scenario, and I'm being very careful not to dive into it because the matter is on appeal,
right,
but more stories are coming out about testimony before the General Legal Council, about collections that we did as a bar, which do not appear to have gone. Apparently, they subpoenaed the secretary to the bar, who testified on how much money we raised to assist this gentleman. And this gentleman says he didn't get all of that money. I have also then now heard a tape, ostensibly, we don't know for a fact, recorded by the lawyer. It raises a lot of legal issues. Did that tape go into the record in the course of the trial? Because in that tape, the client, if it's him, appears to be discounting or stepping back from the allegations. Right? Was this ever put in evidence before? Doesn't it raise issues of lawyer-client relationship, the privilege, and the circumstances under which such information can be used? Is this a proper use of that material? Is it in the course of proceedings, or it is just being put out there in the press? So it raises a lot of legal issues. But my view is that 3 years, I mean, it literally kills the lawyer.
It's practice.
It is practice, you know. And so I thought this was harsh. So let's see what the appeal procedure brings. But my view is that there's a lot of legal issues arising out of this. We all must take a step back and look at the limits of the advertising thing. And maybe it is time to look at the rules itself. Because if you look at the General Legal Counsel Directive in 2013, portions of it appear to conflict with the LI. You see, so we are realizing that times have changed. Maybe it is time. And look, the LI, although it was passed by Parliament, it was made by the General Legal Counsel. And so it might be time for the General Legal Counsel to take a look again at LI 613, particularly with the rules of advertisement, because this is steeped in British law.
Okay.
The British have abandoned this position. The Americans actually went to Supreme Court and abandoned it. Right. It may raise the issue. Maybe this may go to the Supreme Court. Is the limitation on advertising a limit of the right to free speech and expression? These questions come up. But I believe that through the legislative process, we can modernize our laws to take care of this. I, obviously, have a problem with law practice being marketed like milk on TV or like cake on TV. But definitely, we need to look at the rules of advertising again.
All right. And it's interesting also that, well, you say, of course, we cannot purport to want to go into some aspects of it because of the pending nature of the appeal. But there are people asking the question, so if he pleaded guilty, according to what they say, to these charges of advertisements wrongly and also overestimation of fees, charging more than he was required to charge and all of that, then
if you plead guilty,
what is the prospect of the appeal? Okay.
If you plead guilty,
right,
simpliciter, and the facts do not support.
Yes, a judge is supposed to, replace that guilty plea.
But it can also be a basis for
right.
possible appeal.
Okay.
But these are quasi-criminal proceedings. As been held, I believe in, I forget the case, that General Legal Counsel proceedings are quasi-criminal. So proof is beyond reasonable doubt.
Okay.
But if you plead guilty, you forgo a detailed trial.
Yes, I agree. Say, I'm talking about the facts.
Yes. So
if the facts support, you are being charged on certain facts.
Yes.
Right. The particulars of that offense would be.
We will know. We will know if we see the record of proceedings.
Yes, I agree that he asked a question.
Yes.
That the fact that he pleaded guilty, he posed a question.
Yes.
That the man pleaded guilty. So what are the chances on appeal?
It will come out
to the extent that that guilty plea could not be seen to be supporting the fact that you cannot. The facts are said that no, he couldn't have pleaded guilty.
We've heard, and I believe that when we see the record of proceedings, we will know that it appeared that even the guilt plea took the panel by surprise, and they asked, "Are you sure?" That you can verify that. Yeah. Are you careful? Are you sure of what you are doing? Before they moved on with it, but basically, it throws out very interesting issues. Right. I regret that it has to be him. I mean, he was my student. He was a class prefect. I used to meet him more than everybody else because he would come to my office to pick the reading list and we float it to the students. So I am very. Oh, he was your class prefect. Yes. So I'm very sad for him that it has to be on his back that this will emerge. But. Right. Let's see how the appeal goes. I
so since you took it on from there,
but you realize, Mr. Fair used to tell us, clients are bad, though. Clients are bad.
You realize that even the appeal, the appeal is actually questioning the legality of some of the things, particularly, for example, whether that council, the disciplinary council, can constitute itself into a court, so to speak, and to do some of these things. We cannot go into that, but. What do you say?
Well, Samson, let me speak on general terms regarding our profession. Yes, we are using a 1960, 1969 law
67,
to regulate our profession.
Right.
Every year we meet. We organize bar conferences. Every year. We have subcommittees that look into all these. So I think it is time for a subcommittee of the bar to look at this. And when we go for our next conference, it is tabled and discussed so that possible amendment, if we so desire, is effective.
Let's ask a question I have been asking myself.
Yeah.
That when you look at the history of the punishment when it comes to suspension, I don't remember when they gave 3 years.
Yeah.
When it comes to suspension, they do 1 year, 6 months, 1 year, 6 months. I think there was one about 2 years or so.
Yeah, it may appear.
So if they are doing suspension and they are not completely taking you off, they are not withdrawing your license, why is it that this one gets to 3 years?
We don't know the facts.
Yeah, so we need to see the
So
record.
we need to. It may appear outrageous, but we don't know the facts. Sosu was my junior. I mean, I read his profile. He's coming from a very low background. He's worked himself out. I respect him. I admire him and all that. But
he actually runs an NGO,
Yeah.
a human rights NGO.
so to be affected by this, it's sad. But once again, he asks a question. When can you call yourself an expert? If in a field, you're a lawyer, general practice, you specialize in an area, at what point can you say you are a human rights practitioner? Is it because you take more human rights cases? Can you say that of yourself? Can you on your website say so? Can you have a website? I mean, these are all matters that must be looked at. Now about fees.
No, but finish with the rules where they provided the guidelines in July 2013, and the guidelines permit websites. If he puts his number and things on Facebook.
But if it is in accord with the published guidelines, there should be no problem.
There was a further that apparently he commented on cases he was handling and posted the writs of summons and pleadings and commented on the matters. You see, that's why we need the record of proceedings.
Now, on the issue of charges,
but still,
on the issue of
3
fees,
years.
Samson, maybe I can't say them boldly, but when a client comes to me, I look at it, I say, oh, this is your case, A, B, C, D. The nature of it, my effort and all. This is what I will charge. If you can pay, you pay me. If you cannot pay, and I want to do it pro bono, I will do it.
You are not guided by the Bar Association
No,
scale of fees.
I'm coming to that point. You see, the Bar Association is talking about percentages. You are not being told that if I say my consultation is 1,000 Ghana, and somebody says his consultation is 10,000 Ghana. There's no guidelines on that one.
Why not? Because the scale of fees. The scale of fees says if you're a lawyer of this many years standing, you can take up to this much. And if you are doing maybe charging per hour, if you're a lawyer of less than say 8 years, you cannot take more than 1,800. For example, these things are there.
The emphasis is more on the percentage. How much you can charge.
So you are getting a contingency fees. You are not dealing with hourly rates.
No, I'm not.
Look, like the problem is we need to be educated on fees.
Exactly.
And the various kinds of fees that exist. I did a presentation once on the various kinds of fees that exist. For example, if you comment with a client and say, I'm doing this pro bono, which means you are not charging any fees.
As in success fees?
Yes. If you say pro bono, there's no success fee, there's no contingency fee, there's no, I'm coming to court, I want to help you.
Okay.
You at what time does it turn
let's have
pro bono
let's have the
into
non-lawyers
contingency?
say something briefly about this.
We have to be very, very
let's have the
careful
non-lawyers
ourselves.
say something briefly. Koku says he won't talk.
I will study the matter.
Okay.
I feel for the gentleman sentimentally, but I don't know much.
We sent you material. Manasseh wrote copiously about it. We sent that to you as well.
I haven't had time to study it.
Yes, briefly, what do you say?
Studying bombs.
No, he's right. Something.
You are not correct.
Something. But he's right. I concentrated on
I
the
saw he
moment.
was writing with a lot of red.
You may lose the opportunity to say something.
I think, well, we are privileged to have two of his own colleagues. Of course, he said, your profession, now we don't even know how to address you. So
Lawyers.
you know, so for some of us, we are looking at it from a layman's perspective. I mean, when we came, you ran us through some of the principles that we should be looking at. And I was like, 1969, where do we draw the line? I belong to a profession where they'll tell you...
Well, at least your profession allows you to call somebody... does it allow you?
This one is not
free.
under 49.
Now your profession allows you to call somebody...
This
you say somebody has
knows this when we're in
for a
school,
friend.
we used to say...
When it's an institution.
Why do you write your name at an obscure corner of your office as if you are hiding and doing some illegality? But like we say, it's a professional service. So as a professional service, your own quality and success will bring clients so that you are more interested in improving what you're doing. But I feel very sad that in this day and age, and in this day and age, we still are not. It
looks like the gentleman involved in his interview with Joy also was peeved that he claims that Francis had represented that he got him his freedom, and that is not true. He got his freedom, and it is Francis who came in to get him compensation. I don't recall Francis saying that he got him his freedom. Anyway, anyway. So fortunately, this is where we have to draw the curtains on the discussion today. My guests have been Abdul Malik Kweku, Baku, editor-in-chief of the New Crusading Guide newspaper. Asan Kuma is a lawyer, and Isaac Adongo is MP Bolga Central and Finance Committee of Parliament. Alex Kwamena Afenyo Marking is MP Efutu and member Public Accounts Committee and Defense and Interior Committees of Parliament. I'm Samson Ladi Anyanini. I'm your host, and my outfit, as always, is supplied by Latida. Have a good afternoon.